This case is important because I don't want the people to suffer. Yes, I'm suffering. I see the people we are in a location of suffering, in a place of suffering, Piri.
Actually, this court case is very important. It's not only important actually for South Africa, but it's important for the whole world, because prepaid water meters are not installed here only. They're installed in Ghana, and people have been saying, you know, these things are killing us. And we saw, we took a spirit from the precedent that was laid in the UK, where the court said, you know, prepaid water meters are illegal. And we see this as important because it's not only about prepaid water meters, but it's generally about access to water, and also forcing the governments to take water as a human right, but not as a commodity.
So it took us a long time to build that case, and we were only able to launch the case formally in the Johannesburg High Court in July 2006, which we did. And then in around March 2007, the Freedom of Expression Institute decided for various reasons it was unable to continue the case. And at that point, CALS took over as the attorneys of record. Previously, we'd been socio-legal researchers and very much involved in the case, but now we became also the attorneys of record. And the next stage was that in December 2007, we had a hearing in the High Court in Johannesburg over 3 days. And that judgment came out on the 30th of April 2008. It was a completely victorious judgment, an absolutely amazingly progressive judgment, very sensitive to the plight of poor people, but also very good in law as well. And that judgment basically said that the city's free basic water policy was unreasonable and needed to be reviewed, and that people needed to be given 50 litres of water per person per day, exactly what we'd asked for. It also said that prepayment meters were unlawful and unreasonable, which was exactly what we asked for as well. And it said that the city had to provide the people of Piri with conventional water meters, with the option of conventional water meters at the city's cost. That judgment was automatically appealed by the three respondents, who are the City of Johannesburg, Johannesburg Water, and the Department of Water Affairs and Forestry. So they immediately appealed that to the Supreme Court of Appeal, and the Supreme Court of Appeal hearing was heard in February 2009. When there is an appeal, it suspends the status quo ante. So in essence, the previous situation continues. So that was an extremely frustrating thing, obviously, for the people of Piri. They had celebrated the victory in the High Court, and there was incredible happiness about the recognition of their struggle, really, and about the legitimacy of their struggle. And then we had to explain that, in fact, the prepayment meters had to stay. And the judgment from the Supreme Court was in March 2009. After a lot of thought about it, all of the parties, in fact, appealed. So we appealed it, and all of the other parties cross-appealed. So in other words, no one was happy with that judgment. Although, interestingly enough, it also found prepayment water meters unlawful, and it also found the city's free basic water policy to be unreasonable. But it was more in the form of the remedies that we particularly were dissatisfied. And so the final stage is now the Constitutional Court. What we're hoping for is we're hoping that the city revises its free basic water policy and provides a reasonable amount of water for free to the people of Piri. We think that the city has the resources to do it, and we think that they can do so without damaging their revenue stream. We think that that can be done through raising the price of water for very rich and luxury water consumption. We also want prepayment water meters to be declared unlawful and unconstitutional. We do not want anywhere else in South Africa to have to suffer the way that the people in Piri have suffered. So we want the court to declare prepayment water meters unlawful and unconstitutional.
It's my big day today.
How are you feeling?
I'm feeling very happy.
History will be made today in South Africa,
not only in Soweto but in South Africa, and people will know that women will always fight for their water rights. The waterless are coming, Masondo. Down with the Department of Water Affairs and Forestry. Down. Forward with the water struggle. Forward.
We need to take responsibility for our fellow human beings and be serious about human rights. And we'll advance that. This is the beginning of the race, and we'll carry the baton forward in our careers as well, in establishing and making certain that people at the bottom are well taken care of.
Should this case be decided in favor of the applicants, which it should, I think that it's going to be very important in helping pushing us forward in terms of the fulfillment of human rights. So it's very relevant.
And I'm very impressed by the presence of civil society in that community, in mobilizing the people, and while the lawyers are litigating for them. I think that the combination of litigation and mobilization is very good in this case.
Down with the prepaid water meters. Down.
This case is long overdue, and considering that all water in South Africa is not privatized, we should hold the government accountable. This is a human rights issue, which is an interest of ours, and it's about time that we take our natural resources and give it to the people and stop commodifying human lives. And which I think, there's so much emphasis placed on economic development, and we seldom look at grassroots and how people are surviving or struggling to survive at the bottom, and I think this case will change that.